Hey guys, welcome to Hashtag IP series with Rita and Richinda, which features conversations on recent intellectual property cases and trends globally. This could take the form of copyright, trademark, patent, design rights, trade secret, geographical indication, and plant variety. To my new listeners, thank you for making out the time to listen to my podcast. Please come back again. And to my IP friends who returned again, thank you so much for coming back to listen to my podcast. I do appreciate all the streams and plays that I keep seeing. And yeah, let's get into today's episode. So today's episode features remedies available to an IP owner, and the case study for today is a rather interesting and intriguing one. Funny enough, this year made it 20 years that parties have been having this issue when it comes to compensation. So you sue someone, what are the options that are available to you by the law? You don't go to court and then you decide to opt for out of court settlement. What do you do in that event? So you also have issues on ownership and remedies and the IP system in Africa. So yeah, stay tuned. So our case study for today is a rather romantic one. I wish I had told this story in February to celebrate the Valentine's Day. But yeah, if you've ever been in a relationship, specifically if you've ever been in a long distance relationship, you know how hard it is when you want to have those long calls. You're sharing your day's activity, talking about different issues. You get to argue, you get to share mushy messages and conversations, all their I miss yous and their I love yous. And then the call drops. It's like, ooh, what happened? So that was the case with Kenneth Nkosana Makate and his girlfriend at that time, who is now his wife. They were in a long distance relationship and were having difficulty communicating. So I know I've had the experience of being in a long distance relationship. That's too personal, guys. Oh my god. But just to make it clearer, so we had to opt for phone calls, Facebook Messenger, Twitter, yeah, and then you run out of credit. Skype came through, not now that we have Zoom. But yeah, so imagine in 2000 when we didn't have WhatsApp, we didn't have Twitter, we had what app was trending that I can't remember. And then for instance in Nigeria, that was the time when we started using telephones. MTN, Econet were just coming in and people were buying SIM cards very expensive. So imagine that you buy credit of say 100 naira and then it gets exhausted. And then you can't, tell your boyfriend or your girlfriend like, oh, I'm out of credit, could you call me back? So in 2000, Makate, while he was a trainee accountant working with Vodacom Pty Limited, was inspired to create this short text. Please call me. Please call me. And I think that's really cute. And I've seen other IP stories where people had to invent things because their loved ones were affected by something. But I'm digressing right now. But because of the difficulty they had communicating, he just said, okay, I'm going to work on this. And he put this idea into writing, met with his superiors and also his mentor at the office there. And they gave him advice as to, he asked, how can I sell this? Please call me to Vodacom and other service providers. And he was directed to speak with the director of product development and management, Mr. Philip Garcia, which he did. And, the company was really excited about the project and they got talking. And Makate and the company, that's Mr. Gizia, negotiated and agreed that Vodacom will use his idea to develop this product, and he will be paid some money when they make profit from it, but he negotiated that he wanted 15% of the revenue that they're going to generate from this idea. So one thing we need to know again is that IP does not protect ideas. It's very important, because I get those conversations or calls where clients are like, hi Henry, I'd like to patent my idea or trademark my idea, and I'm like, yo, you need to stop. IP doesn't protect ideas. We need to see something tangible. It's an intangible asset, but we need to see something. So what are you showing us? And in the course of negotiation, they did not conclude. It was oral. Everything was done orally. They did not conclude, but they did agree that in the event that they fail to come up with a figure, they will leave that to the Vodacom chief executive officer to determine the amount that they felt was fair. And I don't know how I feel about that. So as you know, in every relationship, there are bound to be issues, dispute would arise, especially when it has to be like commercial, there's money, but even when there's no money. So even in boyfriend, girlfriend, husband and wife, even friends quarrel. And that's what happened. The party, so Makate had issues with Vodacom because Vodacom was not sticking to what was agreed orally. So he took them to court, and the issues that Vodacom was relying on was that first they said they were the owners of the Please Call Me short text and not Makate, which the court disagreed with them, that even though Makate was an employee, there was no agreement stating that whatever work was done belonged to the company. And the company had even gone as far as, in their memos and emails to the staff, acknowledging Makate as the inventor and owner of the work in question. Now, they lost out on that part, so it's been established that Makate owns the short text, Please Call Me. Now pay me what is due to me. And as it is when you go to court, you have to make demands or claim. What are you claiming at the end of the day? Makate was claiming 10 billion rand, and Vodacom refused, stating that they were only going to pay him 47 million rand, and he felt that wasn't enough. So fast forward to 2021. Now in 2021, parties are back in court again, and this is because for the 2 times that they've opted to settle out of court, Makate's team were saying Vodacom were not making good offer. They were saying that they were going to pay Makate the price, give him the money that was equivalent to the then CEO's salary, which they felt wasn't good enough. So now they are back in court saying it will be best for the court to decide the appropriate compensation that will be due and paid to Makate, instead of leaving it to the CEO to determine the amount that should be paid to Makate, or considered fair to Makate. Now remember I had talked about the company stating that they owned the work. Now, how can you determine when a work is owned? This is done by a contract. So if your contract states as an employee, whatever creation you do belongs to the company, blah blah blah, you know that anything you do or invent or create is the company that owns it. But if your contract states that anything you do belongs to you, because now under our laws, as a Nigerian law, the principle is the person who creates the work is the first owner, author of the work. Now, you now have exceptions where it was done in employment or you were hired to do that. But if there's no contract expressly stating that, then you're the owner and author of that work in question. And then you now have... And then the second half focuses on remedies that are available to an IP owner when his work has been used without his consent or permission, and all of those things. So, 1, you get an injunction. Basically, so if the owner is successful in court, he will get an order of injunction restraining the other person from not using the work again. Then the court will also award cost based on your burden of proof, what you prove. If you're able to, convince the court, then you can you can get account of profit. How much have they made from the use of your work? Delivery up or destruction of the infringing property. And I know I've talked about that in the case of Bentley clothing against Bentley Motors, where the court ordered that Bentley Motors should destroy all the clothing that had Bentley written on it. So those are the remedies that are available to a successful IP owner when he wins in court. That's for civil actions. Now, when I first came across this case in 2019, my first thought was, why did they not opt for alternative dispute resolution mechanisms such as mediation, negotiation, arbitration? But parties have been trying to negotiate, and it's obvious that Vodacom has been the one frustrating the whole proceedings. So it's not like they did not explore. So sometimes you have instances where the court gives you leeway to say, okay, you guys should try and see if you can settle this out of court. And then when you do that, you come back to court and then you give a report of the settlement, what you guys have done so far. Then for disputes where there's a contract and that contract has like an arbitration clause or a dispute resolution clause, the court will ask parties to go and explore those mechanisms or alternatives before coming back to the court. I know in 2019 in Nigeria, the CJ, Justice Onogen, then put out there was a circulation stating that if a matter goes to court and it has a dispute resolution clause, parties should the judge in question should mandate parties to go back and settle their disputes out of court. So, question time. What IP was featured in this case study for today? Patent. And I'm super excited about this because, patent encourages inventions, encourages people to, look out for what they can do to solve issues in the society. So basically, the World Intellectual Property Organization defines it, a patent as an exclusive right granted for an invention, which could be a product or process that provides, in general, a new way of doing something or offers a new technical solution to a problem. So patent is like a problem solver. And if you look at the story, McCarthy, because of the communication difficulty they had, decided to invent the short text, "Please call me." So how do you know that your work can be called or enjoy legal support as a patent? One, it must be new and novel, not obviously a skilled person. What that means is that if, say for instance, now you made a chair, a foldable chair, if you give it to a carpenter, he should not be able to figure out what makes it fold and all of those things. It should not be really obvious to the person. Then it should be capable of industrial application. Then another one would be, it should not be subject to morality and public policy. Those are like the basic things. And its term of duration for protection is 20 years. And now, riddle me, guys. Just call me up. This is the 20th anniversary of this case, and patent protection lasts for 20 years. Are you guys seeing what I'm saying? So that's what came into my mind. I was like, this is suspicious. But yeah. So, and then again, there are other forms of IP that IP owners can explore. So McCarthy could have also opted to trademark the short phrase, "Please call me." Now the question would be, is it distinctive enough to qualify as a trademark? Because trademark basically is a source identifier. It has to be distinct. That means it has to be very unique. I think those two, patent and trademark, would work. You copyright the source codes, object codes that were used in creating the short text if they're original and in a fixed medium. So that's 3 now. So that's 3. So moving on, what can we really learn from this? Always consult an IP lawyer in the event I have a dispute, offer a multi-layered IP protection. You can also commercialize your inventions, just like how Makate, sold the idea to Vodacom, but now Vodacom is a bit reluctant to pay up. I mean, pay up, guys. I do encourage out of court settlement because I am an arbitrator. However, we don't have so much precedent. So you go to court and then you're like looking for cases, and then you're like, they're not cases, they're not precedents to rely on. So we need more of these court cases so we have precedents, and that makes it easy for us to develop our own structured IP standards in Nigeria and in Africa as well. And also, now that we have the African Continental Free Trade Agreement, I think it's best that we start putting things in place to have a proper IP structure. Yeah, you can also check out my tweet about it in 2019. You can also check out my newsletter where I shared my thoughts. I shared my thoughts on the case. Take note that this is not an advice, guys. This is just my thoughts. These are just my thoughts and comments on the case, because I did see a publication stating that parties were still in court, and I was like, ooh, sad. But yeah, so I guess we've come to the end of today's episode, my IP friends. Thank you guys so much for coming back to listen to my podcast, and for subscribing and sharing. Please subscribe to the newsletter as well. But yeah, see you in the next episode, or please call me.